जब नंदिता ने मुझे कहा कि मैं यहाँ आऊँ और कुछ बोलूँ, she didn't really tell me the format. So I have, I'm sorry, I'm going to subject you to a little speech. But it is about what we are discussing today. The brazenness of the institutional violence that we have seen in the Bhima Koregaon and the Delhi riots cases is a direct outcome of the statutory text of the UAPA. The statute does not need a finding of guilt to keep a person in jail for years. Its definitions couched in overbroad and vague language, its bail provisions as interpreted by the Supreme Court, have produced a system in which an accusation alone can function as a multi-year sentence. This structure of power is not an innovation of post-independence governments. It draws from a lineage of colonial age draconian laws that were used to counter and contain the nationalist movement. Now the Indian Republic deploys a similar legislative design to brutally suppress political dissent. Section 43D5 of the UAPA states that the court, upon examining case diaries or the charge sheet, must not grant bail if there are reasonable grounds for believing that the accusation against such person is prima facie true. This is designed to keep an accused in custody in perpetuity. If there was any scope for preventing the realization of this potential, it was closed off by the judicial interpretation given to 43D5 by the Supreme Court in NIA versus Zahoor Ahmad Shah Watali. The investigating agency against the accused must prevail until contradicted and overcome or disproved by other evidence. How is an accused supposed to demonstrate that the case of the prosecution does not cross the prima facie threshold unless there is some examination of material, a practice deprecated by the Supreme Court in Watali? And two, how can the material collated by the prosecution be contradicted without evidence being led by the accused? Can this exercise be conducted within a reasonable time frame? If it cannot, is it just, reasonable or fair to hold an accused in custody for a long period of time? It was only a matter of time before the question of reasonable time frame had to be addressed. While the prosecution in UAPA cases is quick to label them as serious in order to oppose bail, there is no parallel urgency to produce the serious evidence in court, test its veracity, and conclude trial within a foreseeable time frame. The idea, therefore, is to incarcerate targeted individuals for as long as possible, denying bail throughout on the ground that there is a prima facie case against them, but not producing the evidence because that would bust their claim. This problem of delayed trials in UAPA cases leading to protracted periods of custody was considered by the Supreme Court in Union of India versus K. Najeeb, where it observed that whereas at the commencement of proceedings, courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provisions will melt down when there is no likelihood of trial being completed within a reasonable time frame. In the years that followed Najeeb, constitutional courts in this country have seen a growing number of cases where UAPA under trials are languishing for years in prison without trial progressing or even charges being framed. In this line of judgments, these courts have followed Najeeb to overcome the rigors of 43D5 and grant bail on the ground of delay. As much as we want to read this as a pro-liberty development in UAPA jurisprudence, we have to concede that this is at best an apology of sorts in the face of a law fortified by the same courts that had all but foreclosed the possibility of bail. We find a peculiar situation where fundamental freedoms in the Constitution have to play catch-up with legislative embargoes on bail, instead of legislative provisions being subjected to constitutional scrutiny. Notwithstanding this, the small window enabled by Najeeb is now the subject of fresh scrutiny by the Supreme Court. In the Gulfisha Fatima judgment delivered in the Delhi riots case in January this year, the Supreme Court held that while prolonged pretrial incarceration triggers a claim under Article 21, this does not automatically override the restrictive bail provisions under 43D5 and requires individualized scrutiny, distinguishing, within quotes, strategic conspirators, namely Umar Khalid, and ground level facilitators, others. A few months later, a coordinate division bench inside Iftikhar Andrawi directly addressed the issue on Najeeb, as stated by Gulfisha Fatima. It said, Najeeb is clear on the position that bail is a rule, jail the exception. Any judicial interpretation by a bench of lower strength deviating from the position would be per incurium vis-a-vis Najeeb, which was delivered by a three-bench judge. Subsequently, in Taslim Ahmed and Khalid Saifi, while granting interim bail, the Supreme Court has made a reference to a larger bench to clarify, and I quote, how Article 21 is to be applied in a statutory field where Parliament has consciously imposed restrictions on bail in respect of offences alleged to affect the security of the state and the stability of civil life, unquote. The grant of bail, however, does not restore individuals to freedom of civic life guaranteed by Article 21. Bail conditions being imposed on the accused in both Bhima Koregaon and Delhi riot cases are also constitutionally suspect insofar as they place all kinds of fetters on speech and movement, effectively ensuring that these individuals remain under prison-like constraints. The recent bail cancellations moved by the NIA against 4 of the BK16 individuals for being together at a press club event demonstrate that the state is far more committed to maximizing the punitive potential of the criminal process than to ensuring that trials conclude with fairness and efficiency. The recent line of UAPA judgments from the Supreme Court contains another alarming development. In Gulfisha Fatima, the bench expanded the meaning of terrorist act in section 15 to include speech-related offences. The text of section 15 leaves no doubt about the use of weapons for physical violence being the essential ingredient. But the court's reading expands the scope of the definition to include speech, which it then uses to deny bail to some of the appellants. The dangers of this expansion of scope cannot be overstated. Making speech a terrorist act is opening the doors to making any and all political dissent subject to prosecution under UAPA. There is now an overwhelming body of evidence of shoddy quality of investigations and prosecutions under the UAPA that contribute to the prolongation of pretrial custody, as both judicial orders and experiences of lawyers will show. In spite of this, the Supreme Court has now chosen to act in a managerial role in suo motu proceedings and directed setting up of additional special courts to conclude UAPA trials within a year-long time frame. The Supreme Court does not seem to be interested in questioning the abhorrent quality of evidence or in considering the serious imperiling of fair trial rights of accused persons in expedited trials, when they often have very poor quality of legal representation. It is instead giving its seal of approval to a mechanical approach of speed railing through trials without any explicit stipulation of fair trial safeguards. This mindless push for expediting is happening in the context of what are already questionable fair trial standards in NIA special courts. The provision for protected witnesses ensures that the witness statements that form the basis for pre-trial detention and denial of bail are supplied to accused persons with anonymizations and redactions to the point of making them indecipherable. And during the trial, the protected witness is placed across an opaque partition out of sight of the accused and their counsel. This practice strikes at the very root of fair trial principles. Without access to the identity and background of the witness or their complete statements, no effective cross-examination is possible. This would be an unacceptable practice for any trial, but is particularly egregious in the context of NIA prosecutions. We are looking at typically voluminous records with multiple allegations against multiple accused persons in offences against the state that come with a high quantum of punishment. The accused often belong to socio-economic marginalized backgrounds with no access to quality legal representation and are incarcerated for years on end which anyway impairs their ability to prepare their defense. It is within this already severely unequal playing field that the special court follows procedures that place their weight behind the prosecuting agency, exposing the accused to even greater prejudice. And it is this precise system which, instead of being subjected to urgent and serious constitutional scrutiny, is instead being fast-tracked, treating conviction as a foregone conclusion and the trial process as a mere obstacle to be rushed through. Finally, the UAPA is considered in principle as an exception to ordinary criminal law. I propose that we do not restrict our scrutiny to UAPA alone, and instead scrutinize the entire criminal justice system, viewing these regimes as differences of degree and not kind. The criminal law system we inherited at independence had an embedded tendency of treating individuals as subjects instead of citizens. The new laws introduced in 2023 have, under the pretense of countering this tendency, actually preserved and even intensified it in some respects. For example, the Bharatiya Nyaya Sanhita has created offences under 111 and 113 by simply replicating the language in special laws like UAPA and MAKOKA. Similarly, 94 of the Bharatiya Nagarik Suraksha Sanhita empowers a court or an officer in charge of a police station to direct the production not just of documents but also electronic communications, including communication devices which is likely to contain digital evidence or any other thing found necessary or desirable for the purpose of investigation, inquiry, or trial. This expansion has happened without any corresponding safeguards or guardrails on the scope of police discretion. We need no better example than the Bhima Koregaon case to know the mammoth potential for misuse here. This is far from being a speculative concern, it is very much a prevalent practice. Criminal law is one of the core sites of the state's prerogative over violence and inevitably produces a disenfranchised class of those who fall within its ambit. The price goes beyond personal liberty and is multifold: bodily integrity, livelihood, personal life, social isolation, and civil disenfranchisement. This disenfranchisement presents a unique problem for democracies. The Republic cites itself as a stand-in for its citizens to justify placing an individual in the borderland between a rights-bearing citizen and a mere subject of the sovereign. While our public discourses and public institutions have periodically addressed this, it most often comes with a caveat of limited empathy, treating the violent excesses of the system as collateral, unavoidable, even necessary. What we are staring at today is a normalization of that caveat by a state operating with near absolute impunity. If that impunity is anathema to democracy, we should recognize that the caveat is also the nullification of a democratic ethos. If democracy entails accounting for the last, most disadvantaged individual, then our public discourse around criminal law needs to be infused with much greater critical scrutiny. As we all know, the weaponization of criminal law is part of a broader context of crumbling institutional safeguards. State agencies are being brazenly used to target political opposition at all levels. Courts have either passive spectators or actively abetted these practices. Fourth branch institutions like the Election Commission have been captured. Corporate media has been tamed, and the space for independent media and civil society vigilance has alarmingly and rapidly shrunk. During the COVID-19 health pandemic, when the Supreme Court asked various high courts to constitute high-powered committees to determine the class of prisoners to be released on interim bail as a measure to decongest jails, the high-powered committees released prisoners accused of murder, dacoity, and rape, but created exceptions against the release of prisoners accused under UAPA and investigated by agencies like the NIA. I would have thought that health vulnerabilities and age would be the basis of the release. The classification for release were irrational and wholly contrary to Article 21 of the Constitution, and as we saw in the case of Stan Swamy, exposed old and vulnerable persons to the virus. Stan's age, his Parkinson's ravaged body, the COVID he contracted in jail, ought to have made him the prime candidate for release. But the deployment of UAPA against Stam made sure that that did not happen. The law was used and converted into a tool of oppression. I did not know Stan Swamy, but I mourn the injustice of his incarceration and ultimately the injustice of his death. Thank you.